learn a lot. It's great to be here, and thank you very much for us allowing to be here. It's always good to have a lot of interest. I can feel the energy emanating from you all. It takes me back to my days when I was at university. It was a little longer ago than some of you guys. I started my legal career in 1966. This is when England won the World Cup in football, the only time they've ever done it. And I qualified in 69, and I never ever thought I was going to be a lawyer. I only took a law degree because it fascinated me. I was interested in history. I was interested in the sort of process, the intellectual process, and the law and the governance and the ability to get round the law, was what intrigued me. And I think that, I find the idea of arbitration, one word which hasn't been used, actually a number of words haven't been used, so I'll come to that, but one word I would use about international arbitration is fun. It's great fun. It really is a fantastic thing to do because you're, okay, sorry, thank you very much. It's like a game of chess. You're constantly trying to be one step ahead of the other guy. You're trying to outthink them at every stage. You're trying to outmaneuver them. You're trying to outlaw them with your legal skills and outfact them with the factual evidence. So it's all about planning your strategy and implementing your strategy. But one word, we heard a lot of words, and I wrote them down, and a lot of them began with C. We heard competitive, we heard confidential, we heard choice, we heard contract, and we heard cost. Now there's one other C word which I think is actually fundamental to arbitration, not only international but also domestic arbitration. Any idea what the other C word is? Gentleman there? That's one, yeah, that's a good one. But someone was saying earlier it's non-adversarial. It is very adversarial at times. So compromise is more the other alternative dispute resolution, which is mediation, where the process is trying to find a solution, not trying to find who's right or who's wrong. Arbitration is more about fault finding, and it is fairly adversarial. Mediation, on the other hand, and conciliation, mediation is basically where two parties come together with the assistance of somebody who's going to intercede, not to find out who's wrong or who's right, but to find a fair solution. So compromise is absolutely right, but not necessarily in the pure arbitration. Anybody else got a C word that they want to add to the mix? Sorry? Oh, this, sorry. Oh, right. What about one of those things that go on your lapel? Because I like walking about a bit. Okay, thanks. So the other, yes, one more C word, anybody? Yeah, that's another one, and that also, so cooperative, compromise. The one C word which we have one more. Consent. Yeah, that's another good one. So lots of C words. The one that's missing, which is the one I always focus upon with my clients, is control. It's the one thing you get from your contract is the ability to control the procedure, control the appointment of the tribunal, control the place of arbitration, control the law of arbitration, control the process, the rules of arbitration. And that is the key in any successful arbitration. It starts right at the beginning. It starts with the drafting of an arbitration clause which gives the parties the control over the resolution of their disputes. And a properly drafted arbitration clause is the most powerful weapon that you will have in an international or indeed domestic arbitration. I mean, I've arbitrated in all over the world: Kuwait, South Africa, India, China, Thailand, Oman, Dubai, UK, France, Germany. And the problems which I've experienced in those arbitrations has been one of a failure of the parties to use the power of control to decide how best they want their disputes to be resolved. And the problem there is that they don't pay enough attention at the early stages of the process, and they don't really think about how they're going to design this process. They want to arbitrate for a lot of the reasons we've heard, for the confidentiality, for the, is that working? Oh, okay. So confidentiality and obviously cost as well. And, but because arbitration clauses tend to be right at the end of the contract, if any of you are familiar with sort of commercial contracts, two things happen. First of all, the parties never really think they're going to have a dispute, so they never get to the point of deciding on the arbitration clause. And secondly, it's always right at the very end. And if you're having a negotiation, it's at that point where it's 3 o'clock in the morning, everybody's tired, everybody's a little bit irritated, and they're particularly irritated with a lawyer who says, well, you might have a dispute. And they say, no, we're going to love each other forever. We're never going to have a dispute in this project. And therefore, the arbitration clause gets absolutely no attention. And they just say, well, just use the usual stuff. And the usual stuff doesn't work normally, unless it's been thought about, because no contract, no commercial negotiation, no commercial transaction is the same as another. So that control requires you to give thought at the very start of the process. And those of you that go out into the world as private practice lawyers, whether you want to be a dispute resolution lawyer or a transaction lawyer, whatever it is, you just have to bear in mind that the client is very seldom right in these things, and you need to guide them. And there will be disputes. And the best advice you can give them is to have a dispute clause which works. Because otherwise, and I know to my cost, as I was saying, in the various arbitrations I've been involved in, a poorly drafted arbitration clause will lead to all sorts of challenges. First of all, how many arbitrators do you want? Do you want one arbitrator, or do you want 3 arbitrators? How are those arbitrators to be appointed? Are you going to appoint them, name them in the contract, or do you have another body who's going to appoint them for you? Where is the place of arbitration? Now, who can give me some guidance as to what is important about what we term the seat, that is, the place where the arbitration is going to take place? What are the important features of the seat of an international arbitration? Any thoughts? Yeah, the gentleman in the back in the green.
So I'm Shivana here. The seat will determine the governing law and the impact of the municipal court deciding the award in the. So I'm Shivana here. The seat of an arbitration will determine the governing law as well as things such as standing of the municipal courts in that seat, the standing of those courts in the arbitration dispute. Like what impact those courts have on the dispute.
Absolutely. I mean, that's a very important and good point. It's the governing law of the arbitration. That means it's the law which governs the procedure of the arbitration. So you'll have in your contract the law which governs the contract, the law which governs the relationships between the parties, but the law that governs the procedure to be followed, how evidence is used, what sort of document discovery, disclosure is to be used, how witnesses are to be dealt with. All of that is the law of the procedure, and it is the seat of the arbitration, which you quite rightly say, governs the law of the procedure. And the other point, of course, which you heard from Mr. Sharma, is, once your arbitration is over and you've got your success and you want to enforce your award, the law of where the seat is will be the place where you will almost certainly want to enforce your award. or alternatively anywhere else in the world where the other party, your opponent, who's lost dramatically, of course, because you're all brilliant lawyers, where they have their assets. But the seat of the arbitration will also determine how the courts are likely to interfere. You want to avoid an arbitration in a seat where the courts are likely to interfere in the process of arbitration. As we've heard, it is all about the parties, it's all about the contract, it's about the choice, and it's about the control. And you do not want to have your arbitration anywhere where those particular rights and powers are in any way subsumed or corrupted by the courts. So this is the world of international arbitration. As Mr. Sharma has said, India is now approaching the need to show to the world that they have nothing to fear about having their contracts in India, having investments in India, because a few years ago, people that were having their contracts in India wanted to have arbitrations held in Singapore, or in Paris, or in Geneva, or in London. Now that was simply because they were concerned that the Indian courts would interfere in the process of arbitration or interfere in the enforcement of any award. And therefore, the government has decided, in order to give the ease of doing business, as Mr. Sharma said, and the confidence of the international community in India, it is enacting provisions which give arbitrators much more power and give the courts far less power. So that is really a very great step forward, and you need to make sure your seat of arbitration is a seat which is safe, it's secure, it has a good and effective legal process, and it has a court system which supports arbitration rather than undermines it. They're having a party outside by the sounds of it. It sounds quite fun out there. Anyway, so these are the thoughts which I think you need to look at right at the beginning. So what I've done in the past, rather than having the arbitration clause at the end, which is, leads the fact that it's going to be the last thing that's discussed, put your arbitration clause right up front in the contract. It's one of the first things that we discuss, and you just have to take your client by the hand and say, you will have a dispute. Undoubtedly there'll be something, and a badly drafted arbitration clause will give the other side a lot of power to delay things. See, one of the other problems with arbitration, we've talked about the differences between court and arbitration. One of the differences in court is that the judges have powers to do things to you which arbitrators don't. So the judges will be able to enforce their procedures much more effectively than an arbitrator. There will be criminal sanctions, contempt of court, all of those things. So that's one of the reasons why people choose the court, because they see the strength of the judiciary as being greater than the strength of the arbitral tribunal. But if you've got a well-drafted arbitration clause and you've got the right arbitrators, then the process should not be undermined by a recalcitrant party, because your arbitration clause would be sufficiently strong to avoid that being done. So I've emphasized that point considerably. It is something which I do believe does require some very careful consideration right at the beginning. Now, as far as international arbitration is concerned, obviously the process is dealt with in a number of institutions. People like Untitled you've probably heard of. The ICC you've probably heard of. Now, can anybody give me some ideas as to why you prefer an arbitration under an institutional rule as opposed to an arbitration which is what we term ad hoc, where the parties decide the rules themselves? Yes, gentleman in the middle there.
fact that it also has some sort of an administrative control. So in case if there is a dispute wherein a party, like for example, a tribunal has been set up, the proceedings are on, and now one of the parties claim that one of the arbitrators needs to go. Now who decides that? So usually under all the institutional forms of arbitration, it becomes easier because the institution then has a body which decides on the biasness of the challenged arbitrator, as to say. While also when we see the unsexual form of arbitration, which is more tailor-made for ad hoc arbitrations generally, but it also comes with a point where they talk about an appointing authority to say that this person will decide who the arbiter, decide on issues which may arise between the parties and the arbitrators. Also, sometimes disputation terms with the fee of the arbitrator, etc., etc. So I think the administrative control that an institutional arbitration offers makes it a more preferred form of international commercial arbitration.
Yeah. Any other thoughts on that issue? No? Well, I think you're absolutely right. It is the security which you get, knowing that there is somebody there who is administering the arbitration, and indeed, with regard to something like the International Chamber of Commerce, the ICC, they will have a secretariat who will be being the person that ensures that fair play is done effectively, and there will be the scrutiny of the award by the ICC once the arbitrators have made their award. And if, for whatever reason, I mean, I've had cases where arbitrators have died, out of boredom in many cases, but they've died and they've had to be replaced. Well, in that event, you need to have someone like an institution, because the problem is, as I'm sure you appreciate, that once you've signed your contract and once the process of the transaction is carrying on, if things go wrong and a dispute arises, your ability to agree anything with the other party is very, very diminished. And therefore, unless there is a process in your arbitration clause or in the administration rules which you've chosen, which allows that sort of circumstance to be dealt with, you're very unlikely to get an agreement, and you may well find that you need to go back to the courts for that purpose. But if I could just deal with another point, which is the why arbitration, and the points that Mr. Sharma was dealing with. It is potentially more efficient. It's potentially less costly. You have the control to have your hearing where you want it and dealt with by whom you want. But the problem is, it comes from people like me and Mr. Sharma, because as we heard from Mr. Sharma, there are various entities, business entities, which have a very quick and simple dispute resolution process. In the mercantile courts in the Middle Ages in Europe, there was a thing called the courts of pie powder. Now, pie powder, for those of you who are linguists, was derived from the French words pied, which is feet, and poudre, which is powdered. So it was powdered feet. Now, why was it powdered feet? Because people came into those courts straight from the marketplace. They had the dust of the marketplace still on their feet, and their justice was dispensed immediately. There were probably no lawyers there, but in my experience, one of the benefits of some of the processes which India has embraced and the UK has embraced in other places, which is something called adjudication, which is a very quick and simple and cheap process of dispute resolution, which is a requirement in the UK for anybody to embark on before they go to court, that although it takes 6 weeks from beginning to end, has led to a dramatic fall in the number of cases that go to court. Because very often disputes arise and get entrenched because of suspicion, because the longer the dispute goes on, the deeper the poison gets and the more powerful the poison gets. And therefore it becomes almost impossible to resolve it. Whereas if you have a swift and cheap dispute resolution process, such as adjudication, the other side, both sides see in a very simple way the arguments, because in 6 weeks you have to encompass your arguments very, very crisply and cleanly with great articulation. So you can't provide, as I have received the day before yesterday, a 500-page defense which one's got to read through, which is in an arbitration. In an adjudication, you have a far quicker and much fewer words. And this has led to a dramatic fall in the number of cases because parties just want their day in court. They want someone, they want to listen to the other side, they want to see their case reduced into as much little detail as possible. They want the other side's case dealt with in the same way, and then they want someone to give them the airtime to have their case heard. And that's really what the principles of arbitration were. A very simple process, over and done with very quickly. And why is it changed? Any ideas as to why it is now a rather lengthy, rather expensive, rather complicated process? The reason is lawyers like rules, and lawyers like rules which are familiar to them. And therefore arbitration has become beset with rules which have their derivation in court procedures. Here in India, in other parts of the world, in the UK, arbitrators are very often lawyers, very often retired judges. They feel comfortable using rules which are familiar to them, which are the rules of the court and the rules of litigation. And that's why arbitration needs to be, your generation needs to seize the opportunity to bring arbitration back to its original process of the alternative dispute resolution process. The reason we have mediation, conciliation, adjudication is because the world sees arbitration has failed to be the original alternative dispute resolution process, the quick, easy, cheap, just resolution of disputes chosen by the parties, controlled by the parties. It's now controlled by the lawyers, and it's become far too complicated. And we're working on trying to remove those complications, but it's not easy. And it is important that you guys recognize that the best approach you can have to your clients when you qualify and get out into the world as lawyers is to look at dispute resolution as something which should be avoided at all costs if you can. Draft your contracts with clarity. Don't leave any grey areas which can lead to confusion and uncertainty. Draft your dispute resolution clause so that it gives you control and you exercise that control. So there can be no doubt as to whether you have one arbitrator or three arbitrators. There's no doubt of what the law of the contract is. There's no doubt as to what the seat of the arbitration will be. Because all of those things, if they're left uncertain, there will be endless arguments. And even someone like the ICC will not be able to intervene in resolving those arguments. Because regrettably, and I say this with care, the ICC and other institutions, SIAC, the Singapore institution, no doubt the Bombay institution and the Delhi institution and the London Court of International Arbitration, they are commercial entities. Where do they get their business from? They get their business from people that have disputes. Therefore, if those two people are in dispute as to the process of whether it should be one arbitrator or three arbitrators, whether the arbitrator should be legally qualified or whether they should be professionally qualified in another discipline, that would be preferred to the ICC, but they don't like making a decision which goes against either party. That's the role of the arbitrators. The administrator doesn't like upsetting the people. So if you end up in a situation where you can't agree with your other side right at the beginning where the arbitration is going to be, how many arbitrators you're going to have, because you haven't drafted your clause right, you may not get a very quick assistance from the administrator because they will upset one of the parties, and that's not good for business. So it's a little bit of a cynical comment, but it goes back to the point which I keep raising about the importance of a clearly drafted contract and a really clearly drafted arbitration clause. And then, of course, the process is, well, do you really need full pleadings? Do you really need your case set out in detail? And how should it be set out? I mean, when I started my legal career all those years ago, I used to sit in court, and it was amazing because you sat there as a junior lawyer and you just listened to the barrister reading from the pleadings. And you got that sense that this may be the first time he's ever read the pleadings, when he's actually in court talking to the judge. And he's learning about the case as the day goes on. And these trials used to last for weeks and months because there was a huge amount of documentation and a lot of oral stuff. It all had to be read out. And I remember the first arbitration I did was in Paris. You know, I wasn't going to read out all the pleadings, but I started by, and it was a very interesting arbitration. We had a Lebanese arbitrator, we had a Kuwaiti arbitrator, and we had an English High Court judge as the chairman. And I was nervous. I tell you, standing in front of a tribunal is nerve-wracking, especially when you have your client sitting there beside you, and especially in this particular case. Because I think this is a case that a very large dispute arising out of a motorway in Kuwait. I'd been involved in it for a little while, and I said to the client, because we have a profession in the UK not fused, I said, well, we've got to the stage now, we've got to think about the hearing, and we've got to think about appointing a barrister. And he said, appointing what? I said, appointing a barrister. And he said, well, what's that? I said, well, that's someone who will, you know, take the thing through and, you know, do the advocacy at the hearing. He said, why do I want one of them? I mean, I've told you all about this case. Why don't you do it? Well, I'm not a barrister. Well, you can speak. You know, you're quite capable of raising arguments. You do it. So at this point, I thought, well, you know, that's going to be fun. This was my first approach at an arbitration. And then he probably sensed a little bit of nervousness over the ensuing months. And so he said, look, when we start, Martin, I will talk probably for about a day and a half or 2 days. I want to sort of, as a layman, as an engineer, I want to explain to the tribunal the justice of our case. I want to explain the history. I want to go through the process of the way in which this work was planned, the problems that we occasion, and just get the tribunal to understand that we're the guys who are right. That's fine. That's fine. So I went into the first morning expecting not to say anything for a day and a half, and he stood up for 35 minutes and then sat down again. and then said, Martin, over to you. So I thought, oh my God, I'm not fully prepared for this. So I started saying to the judge, well, I'd like to just explain a little bit about the case, Your Honour. This is a case about... And the chairman said, Mr. Harmon, we can assume, you can assume that we've read all the documents. You can assume that we've read all the pleadings. What I want to know is what your client's case is in relation to the argument on Clause 36. And I thought, Clause 36, I wasn't going to get there until about day 4, but that's what an arbitration is all about. It's huge. The pressure is great, but the fun is enormous because, you know, you're constantly trying to get one over on the other side. And the other great thing about international arbitration is you meet so many interesting people. And you meet a fair number of stupid people as well, particularly on the other side. And I was saying to Tusha on the way here, the easiest opponent is another good lawyer, because you can have a sense of what they're going to do, and you can plan your moves ahead, and you sort of, like your game of chess, you plan your moves anticipating their reaction, your counter-reaction, so therefore a few steps ahead, your strategy is planned to perfection. The stupid guy will do things which you had no anticipation of whatsoever. It'll come out of left field, you will not be prepared for it at all, the judge will be taken in by some emotional argument, and then you're left with this disaster booming because you've got this very dumb, stupid lawyer who happens to have found a weak point in your argument just by pure chance. So, you know, it's always nice to have some bright people on your side. It's also quite nice to have bright arbitrators. I've encountered a lot of arbitrators who simply, maybe it's just my style of oratory, but they seem to fall asleep. They just sit there and you think, are they listening? Are they asleep? Maybe they're dead. You know, because they don't make any sort of attempt. And these are the problems with the old arbitrators. They never used to show any sign of life. So the interaction with the tribunal, you didn't know whether your point was burrowing deep into their brain and they think about it, or whether they were just thinking about what they were going to do on the golf course the next day, or whether they were dreaming, or whether, I say, they'd passed away. You had no idea. So you have to sort of keep trying to develop your argument and try and get some sort of response from them. And others, you will find, won't let you get a word in. They will interrupt you at every sentence. So you need to be very aware culturally, because, I mean, I dealt with a case involving a Saudi Arabian client, and we had an Egyptian judge as our chosen arbitrator. I say chosen, imposed arbitrator from the ICC. And he was about 90, I'm sure, and slightly hard of hearing, and was just set in his ways. He'd never done an arbitration in his life. And he would not let you get a word in. And one of the things about arbitration is, you know, there are certain rules, certain requirements and procedures. And one of them is you don't talk to the arbitrators alone. You know, the parties have to be there. You can't ring up the arbitrator and say, oh, I forgot to mention in my hearing. So I was having coffee during one of the breaks in this hearing, and one of the tribunal members came and said, Mr. Harmon, would you, the chairman would like to have a word with you. And I said, oh, God, I thought, what have I done? You know, he's woken up and he's missed 3 days of my hearing. And so I went in, and he said, oh, Mr. Harmon, thank you for coming in. I would like you to develop for me the argument you were raising, you know, just before the coffee break. And I said, I'd be very happy to do that, sir, but I'm afraid I'd need to ask my opponent to be here as well. And he said, I don't want him here. I don't want to hear him. I want to hear you. And I said, I'm sure that's absolutely right, sir, and I'm delighted that you want to hear me, and I'm sure, you know, he will sit there very quietly, but he needs to sit there. No, Ms. Harmon, you don't understand. I want you and you alone to be here. And I said, sir, I find that very difficult because it will lead to possibly this arbitration being challenged because of lack of impartiality. Mr. Harmony, are you disobeying a rule of this court? And I said, it's not a court, old chap, it's an arbitration. But anyway, and he was just in mode of, I'm a very experienced, very elderly Egyptian judge, and I'm going to send you off to prison for contempt of court. And you know, it was only when one of the other tribunal members came around and said, Mr. Harmon's got a point here. You know, but you do have to, you have all sorts of strange and wonderful things happen to you in the course of an arbitration. And of course, your client is possibly the strangest and wonderful thing of all, because they will decide to come up with facts which you were blissfully ignorant of when you started the case, and which perhaps you need just to sort of do a little bit of finessing, because it could cast a large hole in your credibility. You have witnesses who, when you talk to them, when they write, are the absolute last word in articulation and persuasion. When they get into court, they're just a gibbering mess of sweat and impossibility. And that's where, you know, we talk about expert witnesses. And my definition of an expert, X is the unknown quantity, and spurt is a drip under pressure. And that happens in many cases where your expert witness just dissolves. So you have to plan them, you have to go through their evidence with them, you have to have, you can't coach the witness, but you do have to try and give them some guidance as to how it all goes. So there's a lot of planning, a lot of strategy, a lot of forward planning, starting with the arbitration clause, but a lot of fun as well. I mean, I do envy you, because here I am in the twilight of my arbitration career, and I still get a real kick out of doing it, and I'm sure you guys will as well. But, you know, you're young, you've got this wonderful opportunity ahead of you, and I do hope that you will, you'll take it. Working, of course, with Link Legal, the best law firm in India, but somewhere, I'm sure you'll find your place to work in arbitration. So now, I've just gone off piece a little, but do ask Atul and I any questions. Don't make them too technical or legal, because, you know, I've lost, my law is the law which existed around about 1975. So anyway, thank you very much for listening, and please carry on the debate.
Hello, sir. Good morning. My name is Ria. Sir, I just want to ask you that how exactly do we enter the field of arbitration? Because like we have some idea about litigation, that you need 10 years of experience, and then you like practice under a senior advocate, and that's how you enter litigation. But what's the scope of entering arbitration? Do we do an LLM? Does that help? How exactly do we go about that?
Yeah, I mean, that's a very good question. I mean, I think it's always good to join a firm which has a very good arbitration practice. I mean, very often, you know, arbitration is just an adjunct of a corporate practice, you know, because you've got your corporate clients will get into disputes, and many disputes will be resolved in arbitration. But I think, you know, if you look at people like the Chartered Institute of Arbitrators, you know, you can join the Chartered Institute of Arbitrators as an associate at any stage, and you'll get to go to various meetings. You can sit with an arbitrator. They're always very keen to train people, because arbitrators tend to be people of my sort of age, you know, former lawyers, and they're really looking for younger people to be arbitrators, younger people to specialise in arbitration, not just as arbitrators, but also as advocates. And the other thing, just a plug for a thing which I used to do in my old firm, in King's College in London, there is a postgraduate degree in sort of, it's construction law, but it's basically construction law arbitration. So it teaches lawyers about construction law, it teaches other professions, civil engineers, quantity about arbitration, about dispute resolution. So there are a number of courses you can go on, but the Chartered Institute of Arbitrators is probably a good starting point, just to learn a bit more and to show that interest in arbitration, which, you know, a law firm will recognise and will be very necessary.
Yeah, in the Indian context, I think what is not very clearly defined is the distinction between arbitration lawyers and court lawyers. Over the years, all court lawyers have doubled up like me as arbitration lawyers. But if you do an analysis, you will come across data which will really let you identify that who are the people, and it's not necessarily firms, not necessarily big firms. There are smaller firms, there are individuals who have been doing arbitrations. There are senior counsels, a large number of senior counsels who will be doing arbitrations. You will be surprised that a large number of arbitrations for the biggest construction company in India, Larsen & Toubro, are being done and have been done by individual lawyers. And there are senior counsels, I can name one, Mr. Rajadhaksha, who is a senior counsel in Bombay, who is doing a large number of arbitrations in for electric and other construction companies. So you need to do some groundwork. Once you've done that groundwork, so on the professional side, you can probably shortlist them and work with them. On the intellectual side, as Martin said, Chartered Institute of Arbitrators, you want one of my partners in Bombay is the India Secretary General of CIR. So you can probably get in touch with him, get some guidance. He conducts courses for training of arbitrators. You can also look at certain courses online. Two of my colleagues have recently done a course which is not purely in arbitration, but it is useful in arbitration. For example, there is this course on project management. It is an online course done by the Royal Institute of Chartered Surveyors, London. You also have institutions doing some training. Nani Palkhiwala Center, which was originally in Chennai, set up in Chennai, has now opened recently, about a few months ago, opened a facility in New Delhi, in Barakhamba Road in Gopal Das Mohan. You could also go and check with the ICC. Abhinav Bhushan is a person in charge of India. You can send a mail to him and say that you are interested in arbitration practice. Are there any courses which he would recommend to you? You can even go to the SIAC, India representative. You can go to LCIA. Of course, LCIA has wound up in India, the operations, but they're still there in London. So there are the large number of places where you can go and meet if you want any introductions. You can go, meet them, understand how the whole ecosystem of arbitration is functioning in India and internationally. You can go to Niti in the Mumbai Center for International Arbitration. Niti Mohan is her name. You can interact with her and see and just get a download on who are the people who are key practitioners and how they approach them. Are there any formal training programs which have been conducted? So if you do that, you'll get a very good sense on what the career path is for you on the arbitration side.
So, Abhishek from the fourth year. So, I was just wondering, there was a recent US Supreme Court judgment that allowed for mandatory arbitration clauses in employment contracts. Do you think arbitration is beneficial in such contracts? It allowed for mandatory arbitration clauses vis-a-vis employment contracts. So, for example, a person working for a company could be forced to only go to arbitration if he had any dispute with his employer. He would not be allowed to seek any other judicial redressal mechanism. Do you think arbitration is useful in such contexts? Because I feel like when the power dynamic is so skewed that it could be really bad for small workers and stuff like that, as opposed to big corporations, since they don't have much money to fight these arbitrations.
Yeah, I think you're probably right. I think it is the David and Goliath thing, because arbitration will require a fair amount of cost. But if it's arbitration before a specialist employment tribunal, then that might work, because that would avoid the problem of otherwise having to go to court, which is very intimidating for a small employer, for a small employee, unless the employee works in concert with a trade union or whatever. But certainly the idea of some sort of conciliation and arbitration service in relation to employment is a good one, but it is more about conciliation, trying to find some sort of solution rather than finding blame or fault. So I think that the mandatory side of it is unfortunate. I don't know how that would be enforced, but every employment contract, they would say, would have to have this clause in it. Yeah, well, I mean, it depends what the clause says. If it is a sort of conciliation, we try and have a process which arbitration is the end result, the final conclusion, which hopefully won't be reached. But before that, there are a number of tiers of dispute resolution, like conciliation, mediation, which you go through. Then one would say that's quite a good idea, because it would avoid a court action. Do you want to? I think this goes.
Yeah. So this would be fine. See, you're talking of an American case, right? In Indian context, it would be slightly different. See, obviously, there's nothing precludes an employer and employee saying that in the event of a dispute, we will go to arbitration. But when it comes to your statutory rights, and there is a mechanism in the statute, say for example, collective bargaining. So, say for example, can you say that a dispute between me and my employer, I understand an arbitration agreement, but there's a scheme of collective bargaining recognized by law, the Industrial Disputes Act, etc., will this supersede? But it is yet to be tested. But I believe that that would be contrary to the statutory provision of a collective bargaining process which you have to go through. So, in India, I don't think you could ever have an arbitration clause in an employment contract. And I think its sustainability, unless it is a private dispute between the two, you should get 100 rupees, or you should get 500 rupees, or you should get an improvement, etc., etc. Because there's so much of subjectivity in an employment situation. Now, I'll take it at another level. If there's a contract for employment, can it be enforced? Can I say to Mr. Employer, you must make me work and pay me money? It doesn't work. The law does not recognize it. Says a contract which is personal service cannot be enforced and only damages is there. So the questions like termination, questions like compensation, if you have agreed on specific items, yes, but in a ballpark industry dispute adjudication, I have my doubt to enforce it.
Sir, this is to Martin, sir. I'm actually Sujit doing my 4th year. So you said that lawyers are making the arbitration process more slower and ineffective. But when the transactions get complex, don't we need them to understand the entire process to get a very just arbitration?
Yes, of course. I mean, you're absolutely right. We do, fortunately, have a role in life, but it's just the process of arbitration need not mirror all the procedures of litigation, particularly when those procedures don't have the enforceability which a judge gives them. So it's it's the idea that you can't have much. Everything has to be done in orally. Witnesses are cross-examined orally. experts do write orally, so things like, a lot more emphasis on written testimony, on written memorials, on exchanges of witness statements, getting things sorted and agreed rather than sort of having the dispute aired, through the oral arguments of barristers. That the amount of documentation which is required, this full disclosure of all documents, all of these things just weigh down the arbitral process and don't necessarily add to the justice, because there is very few arbitrations are clearly black and white. There's always areas of grey, and nobody comes out of an arbitration saying that was great, I'd love to do it again. They always come out wiser and poorer, no doubt, and they don't come out wanting to do it again. But if we can, as lawyers, make it slightly less festooned with these rather litigation-style procedures, and this is happening. It's happening in India. It's happening around the world. In international arbitration, is becoming recognised as I said, the alternative dispute resolution process. But it's taken a long while, and in the last 30, 40 years, the lawyers have caused it to be polluted with these litigation-style procedures. But don't get me wrong, obviously, any case that needs to be decided, there needs to be justice, there needs to be due process, and things cannot be shortened just for the sake of it. Otherwise, the award won't be enforced. So you need to go through the processes, but they needn't necessarily be the slightly arcane processes which we're used to in court.
Good morning, sir. I know it's slightly off topic, but how do you feel about the future of arbitration in the field of small export and import businesses, especially in the international scenario, considering that we're having a lot of them come up today? So, for example, in the medicine industry or in the clothing industry or in the spice industry, we have a lot of small businesses that have been coming up, and the amount of disputes in this area is increasing manyfold, with very little to no recourse to a lot of people at a lot of points in time. How do you feel the future of arbitration is going to go in a field like this, where small businesses are generally unable to afford such expensive procedures?
Over to you on that.
Yeah, of course, there is a huge potential of making a successful methodology for small businesses for resolving their disputes. I'm quite, if you look at, there are 2 or 3 levels of even institutional arbitrations in India, which is today the institutional arbitration is heavily loaded in favor of big international contracts, big parties, MNCs. But once we get used to the new procedures of fast-track arbitration, we have a fast-track arbitration now, like Singapore recognized in the Act. Once we get used to, creating, for example, the Delhi High Court, which is the Delhi International Arbitration Center, it is seriously considering, and I was talking to Justice Muruga the other day at one of the functions. That's where they said that we really want to make this body, at least a part of it, affordable to small businesses, even white businesses, even family disputes where people spend years and spend monies, thousands and lakhs of rupees going to the lawyers and courts, and even matrimonial for that matter. I think if you look at how the Delhi and a large number of high courts, the mediation centers which are attached to them, even criminal cases which are interstate parties are being sent for mediation. So, surely for smaller businesses, as things move along, there will be large number of opportunities, and SMEs, as the government calls it, will surely have a good opportunity. It's a huge future for them because they obviously can't go through a full-fledged process of evidence from 1,000 pages of documents, etc., etc. And that's where, the point which I mentioned of trade bodies themselves coming out with, there are some chambers of commerce, and this has been discussed when I was the president of the Indian-American Chamber. We did discuss this, that would we really start a process of, and that was a bilateral chamber which was catering to not the Raytheons and the oracles of the world, but it was catering to mid-sized businesses who had factories in Guyana. Why can't we create an institution where these fast-track procedures can be, implemented and disputes resolved? I'm sure there are a large number of bodies. I in fact was approached by one of the bodies which was representing SMEs, but for some reason it never took off. So they will be going ahead these possibilities.
Just a small follow-up, sir. Considering that a very important part of arbitration is how it's an alternative to the traditional court system, especially with regards to the amount of time and the amount of scrutiny that the arguments from generally both parties go. Keeping that in mind, sir, how effective would fast-track arbitration be with vis-a-vis conventional arbitration? Considering that a very important part of arbitration is how much time we extend to the counsels, especially with regards to the scrutiny that the arguments go through.
No, you see, let's not forget that fast track is something which is with consent of the parties. So that 6-month process is available only when you agree to go through that. And obviously, fast track necessarily means that you don't go through the rigors of a formal evidence or formal review of documents. And it's a very first cut kind of a justice system where, but of course the fact remains that arguments will still be relevant. Maybe what you can cut through is the whole process of discovery, inspection, or proving documents and relying on large number of oral evidences, etc. But the fact remains that the fundamental principles of determination of the rights of the parties would obviously be on legal principles. So you still have to argue your case. And so I think what I could sense from your understanding was that you're mixing up the arguments and the evidence. So evidence change can be portrayed, but surely the argument should be available to parties. They can't go through a process which is so summary that the arbitrator does not even understand the basic nuance of the points involved and how to read the contract, implement the contract, and implement the law, and understand the contract in the context of the